Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration.
Do you ever feel like you're spending more time on paperwork than practicing law? Many firms lose nearly half their day to outdated systems. This free guide to the best immigration software for law firms in 2025 will help you fix that. E-Immigration compares the 6 leading platforms side by side, so you'll know which software actually reduces admin work, protects client data, and helps your team work faster. Stop drowning in forms. Start practicing law. To get the guide, head on over to get.eimmigration.com/resources or save time, click on the link in the show notes.
And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello, everybody. This week, friend of the pod, Marianne Staniunas, pro bono immigration counsel at Ropes & Gray, wrote me, telling me that she knows that I always want to know the end of a great story. And that's true. Her story is that this week, after over a decade, Mr. Alfonso Estuardo Mendez Esteban was granted political asylum. That's the Mr. Mendez Esteban who got quite the remand in his Guatemalan political opinion case on episode 159. Marianne reports that Mr. Mendez Esteban was thrilled and then immediately asked about his family. Ropes & Gray apparently is going to try to make it happen for the family too. Congrats to Marianne, the entire Ropes team, and everyone involved for this well-represented asylee. Also this week, and it did not take long at all, remember that wild decision about administrative stays from the unnamed panel in the Ninth Circuit on episode 287 that seemed to be throwing down the gauntlet against the Ninth Circuit Clerk's Office and other Ninth Circuit judges? Well, that decision is now stayed, and the court's almost surely going to go en banc sua sponte, said the court this week. Fighting going on in the Ninth. That's Rojas Espinoza et al. V. Bondi. I'm sad I had to miss the AILA California conference, by the way. I'm sure it was great, but as you can all hear, I am still getting over these infant-induced colds. And finally, on this eclectic introduction, dedicated listeners will recall my son's appearances at the end of each episode to rate the show. He always rates highly. Careful listeners will note as well that I always suggest that if you like what you heard, you can send me your own kind sounds. Some of you might assume that those are hollow words, but I mean what I say. Always. But no one has taken me up on it. Until now. Check out this fantastic review from listener Dan Gray in Tennessee, provided by someone in his family named Dogs.
I thought that was a pretty snazzy podcast by Kevin. What did you think, Dogs? Well, I agree.
Indeed. If you've got sounds, I want to hear them. No sound left behind. Only 2 cases this week. Nothing great for non-citizens, to be honest, but of course, worth your knowing and intellectual curiosity. I'll get to them in just a sec. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS. But that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200. Our first case is from the BIA, matter of Cahuec, Tzalam, published by the BIA. This case is about administrative closure. There's a whole Biden-era regulation for that now. The BIA continues to chip away at it. Pro se non-citizen before the BIA too, by the way. And yet another grant of DHS's interlocutory appeal. That once exceptional thing that is starting to seem less exceptional, at least when DHS is the one requesting interlocutory action. Mr. Cahuec Tzalam is by definition young, because he is pursuing special immigrant juvenile status classification before USCIS. He is in fact 18 years old now, and he's from Guatemala. He came to the United States at 16 years old. I don't know that much about SIJ, but I imagine he got a state court order declaring him dependent and that it is not in the best interest for him to return to Guatemala, because he filed an SIJ petition with USCIS in April 2025. And it was on that basis that he asked the immigration court to add and enclose his case, which the IJ did. And again, this 18-year-old is now representing himself before the BIA. Loathing the administrative closure, DHS interlocutorily appealed. And the BIA deemed it so important to reverse that the BIA accepted the appeal and reversed and remanded. Or vacated and remanded, whatever you do with an admin-closed case. The BIA first lists the various factors to consider for administrative closure from 8 C.F.R. section 1003.18 C.3.I. According to the BIA, that regulation codifies and expands the matter of Avitesian factors. Don't say Merrick Garland didn't do anything for immigration, folks. There was this one thing. And clearly disliking the very regulation that the agency promulgated, its own agency, the BIA includes a 23-line single-spaced footnote attacking administrative closure that also all but begs DHS to provide briefing in the future, explaining why admin closure, quote, infringes on its legal authority and ability to enforce the immigration laws, end quote. If you need some context about the tribunal deciding this interlocutory appeal. Quoting its own 2025 decision in matter of BNK that, at the time to me, did seem to indicate the BIA was trying to rewrite the reg a bit, the BIA quotes here and explains, quote, although no one factor is dispositive, whether there are persuasive reasons for a case to proceed and be resolved on the merits is the primary consideration in determining whether administrative closure is appropriate under the totality of the circumstances, end quote. Quote, there must be some foreseeable resolution, end quote, explains the BIA now, again, adding a non-regulatorily listed factor, it appears. So with SIJ, explains the BIA, after getting that state court order, first the non-citizen must file and get approved a Form I-360, and then the non-citizen must file and get approved a Form I-45. So it's a 3-step process with 3 steps of delay, none of which is the fault of the child. Additionally, SIJ visas are oversubscribed. At present, the visa bulletin lists a delay of over 5 years, explains the BIA. restated to adjust status with an SIJ-based visa today, that I-360 had to have been filed in July of 2020. Also, not the child's fault, that oversubscribed delay. In this case, the non-citizen, who was represented before the IJ below, only submitted the USCIS receipt notice to show that they had an SIJ application pending. Nothing else. As such, explains the BIA, quote, the respondent did not present any other evidence demonstrating his prima facie eligibility, end quote. You do gotta generally do that to get an admin closure for collateral relief, and so that would appear a fairly easy fix for similar cases in the future. Quote, submitting the juvenile court order is particularly important, end quote. Hard to argue with that. But of course, the immigration bar cannot have nice things during this, the second coming of Trump. Quote, even if the respondent had established eligibility for special immigrant juvenile classification, the indeterminate and likely lengthy period of time until he would be eligible to adjust status if his petition were ultimately approved by USCIS also strongly militates against administrative closure, end quote. Long time to wait for a visa to become current, explains the BIA. But it is known, so what's the problem? Well, 5 years is not a, quote, reasonably short period of time, end quote. Again, a requirement for admin closure that the BIA appears to have made up, and that is not contained in the regulations promulgated literally for the purpose of describing the requirements of admin closure. Unless I've missed something. Also, something that SIJs have absolutely no control over. But as such, the BIA believes it important to proceed with removal proceedings so that Mr. Cahuec Tzalam, who very well may have a direct path to a green card in America, can get ordered removed and physically removed before that day comes. Possibly. This is, after all, what DHS wanted, explains the BIA, and the opposing party's opposition is important, explains the BIA. Having said all of that, the BIA concludes by implying that a lot of that was dicta. Quote, given the respondent's failure to submit evidence of his prima facie eligibility for SIJ classification and the extended delay in the availability of a visa, the immigration judge erred in granting administrative closure, end quote. So that's the actual holding, right? Gotta have both of those failures? A different outcome should be possible if you establish prima facie eligibility for SIJ classification. But like many BIA decisions these days, before that holding, the decision is filled with quotes that an IJ may use, should she or he desire, to rule against a non-citizen. In my opinion. And it all got sent back for the case to be set for a new hearing. And that is Marab Cahuec Tzalam.
Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in.
Founded and led by veteran immigration attorney Irina Rostova,
EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists.
Doing business as Invest America. Let me guess. You've probably had enough. Too many late nights, endless pings, and that constant fear that if you step away, everything will fall apart. This holiday season, you deserve to log off with your tasks taken care of. With Staffy Live, your 24/7 specialists will handle every call, qualify every lead, and keep your firm running while you're making memories. And with staffy outsourcing, you could delegate your first 3 cases completely free if you sign up before the year ends. You built your firm for freedom. Now, let Staffy help you live it. Visit www.staffy.cc, that's stafi.cc, or call 786-891-5619 to start spending time on what truly matters. Our final case is Solis-Flores v. Bondi, published by the 4th Circuit on November 13th, 2025. I told you, short week. And this case has been on the podcast before. Episode 177. Back then it was primarily about whether receipt of stolen property in violation of Virginia Code Section 18.2-108 is a crime involving moral turpitude. The 4th Circuit held back then that it was. Here's the thing, though. The 4th Circuit did so, back then, by applying Chevron deference. Counsel got the Supreme Court to therefore vacate and remand this case post-Loper Bright. Smart counsel. But, quote, we conclude that Loper Bright changes the analysis, but does not alter the result here, end quote. Still gonna do it. Short week. And it's a new decision. To the panel, the 4th Circuit has itself developed a CIMT definition that is consistent with the BIA's. How coincidental. In the 4th Circuit, quote, moral turpitude refers to behavior that not only violates a statute, but also is inherently immoral, that is inherently base, vile, or depraved, end quote. I'd have thought personally, though, that somewhere along the way of developing that definition, the 4th Circuit would have relied on Chevron deference, making the whole definition possibly suspect, but that is not discussed by the court. Here's what else a CIMT finding requires in the 4th Circuit. Quote, such a crime requires 2 essential elements, a culpable mental state and reprehensible conduct, end quote. Quote, to satisfy the mens rea element, a crime must require an intent to achieve an immoral result or willful disregard of an inherent and substantial risk that an immoral act will occur. To meet the actus reus requirement, the crime must involve conduct that violates a moral norm, end quote. So laying out quite comprehensively the CIMT definition in the 4th going forward post-Loper Bright. You know what I didn't hear, though? Any special framework for theft crimes? And you know what I also didn't hear? A rule that fraud crimes are CIMTs even without having to satisfy the reprehensible conduct prong. The 4th Circuit does explain, of course, that the categorical approach applies. So we have, again, Virginia receipt of stolen property. To commit that, you've essentially got to buy or receive or aid in concealing goods that were stolen by someone else, knowing that they were stolen by someone else and doing all of it with a dishonest intent. To paraphrase what the 4th Circuit says the standard is under Virginia law. Mr. Solis-Flores argued that someone could actually be convicted despite intending to return the property to the rightful owner. Quote, a joyrider who borrows a car from a friend, knowing the friend stole it from a third party, but who intends to take the car for a drive and then return it, not to the thieving friend, but to the third-party owner, end quote. It's possible, says Mr. Solis-Flores. The 4th Circuit isn't so sure, given that, again, Virginia case law makes clear that having a, quote, dishonest intent, end quote, is an element of the offense. Mr. Solis-Flores persists, though, that because technically an intent to permanently deprive the owner of property is not required to convict, it can't be a CIMT. Not only is Mr. Solis-Flores making this argument because it would enable his hypothetical, but as clever listeners would identify, this was essentially the element required to make most theft-type crimes CIMTs pre-matter of Diaz-Lizarraga, a definition that I'm fairly sure applies to the date of the crime at issue in this decision. Although, as the 4th Circuit explains later, the BIA has also long had a slightly distinct CIMT definition for receipt of stolen property type offenses. Anyway, before diving deep into this, query why, if the 4th Circuit isn't talking about a special rule for theft-type crimes, or considering whether a receipt of stolen property offense is a CIMT at all, without some independent explanation of why such crimes are morally reprehensible as compared to other crimes. Don't get me wrong, they might be, but I would expect some discussion, given that being morally reprehensible is a very important element of the CIMT analysis. But that's not really the conversation the Fourth Circuit's having. I need to have the conversation they're having. The first problem to the court is that Mr. Solis-Flores didn't identify a case in which someone was convicted without an intent to permanently deprive the owner of the property. The realistic probability test. Mr. Solis-Flores is trying to use it as a shield against a statute that the court believes satisfies the CIMT definition, but he did not find a case. Would appear the court's analysis. But second, here we go, what I was actually desirous of. To the Fourth Circuit, the BIA and other circuits have recognized that, quote, it is morally wrong to possess property knowing it has been stolen from its rightful owner. Such a crime speaks to the honesty of a person, end quote. The panel appears to agree. That many of those circuit decisions relied on deference to the BIA's CIMT definition is not overly problematic to the panel, as BIA precedent can still serve as, quote, persuasive authority, end quote, apparently. Particularly when the circuit's INA definition aligns with the BIA's. As such, for receipt of stolen property offenses, the BIA's, quote, salient element, for purposes of moral turpitude, is the defendant's knowledge of the stolen nature of the property, end quote. Seems like the Fourth Circuit agrees. And it disagrees with Mr. Solis-Flores' well-researched counsel's arguments that really old BIA decisions require an intent to permanently deprive, even for receipt of stolen property offenses. In so holding, the Fourth Circuit expressly disagrees with the Ninth Circuit. In that case, Castillo-Cruz v. Holder. One final fabulous argument was rejected as well. In 2008, a Virginia appeals court affirmed a conviction against a lady simply because her partner stole property, sold it, and then used the proceeds to support the lady and her child. Surely not turpitudinous conduct then, right? The ladies, that is. The problem is that the Virginia Supreme Court vacated that conviction the next year, and quite directly, too. But, argues Mr. Solis-Flores, that all means that at the time of his conviction in 2000, someone obviously could have been convicted of non-turpitudinous conduct, right? It literally happened. The Fourth Circuit didn't buy it. And I'm starting to get deja vu, so maybe I said the same or similar thing 113 episodes ago, but I don't know. Seems pretty convincing to me. Hats off on the argument in any event. But it does look like the end of the road for Mr. Solis-Flores. Might we have a trend? This week, the Ninth Circuit instructed the clerk's office to amend its Episode 269 decision at page 28, footnote 4, to write, quote, we conclude independently, without reliance on our precedents at this step, that petitioner was convicted of a crime involving moral turpitude, end quote. That decision was about a lot of things, but that portion was about shooting a firearm at an inhabited dwelling in violation of Cal Penal Code Section 246 and whether it's a CIMT. Seems like the Ninth Circuit is trying to make clear that it's definitely not relying on Chevron deference to get to the same result. So I do think the greater takeaway is that circuits are still feeling out how to decide these cases post-Loper Bright, especially in the CIMT context, and that a lot of judges very much believe that the law requires that they keep their old precedent in some way, shape, or form, but with some semantic tweaks. Keep fighting, though. Cracks are developing. And that is Solis-Flores v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.